Okay.
Yeah.
We have Mr. Dowdy for that withdrawal.
Okay, which one? Lopez?
Person, yes, okay. The other one.
Okay, go ahead and bring him on. Mr. Dowden?
Yes, sir. Judge, I'm here.
Okay, let's start with Lopez. You've got a motion to withdraw as attorney of record that was filed on April 23rd.
I do.
The sense of the withdrawal is that you have been unable to communicate with the movement.
We've not heard back, Your Honor, from the applicant and Ms. Kirchmer. This is a case that we got from the Bar Association, a pro bono situation. And Ms. Kirchmer had emailed me a couple of times. It has to do with the funding or whatever and needed me to go ahead and file a motion to withdraw. And we haven't heard back. That's our primary reason. But a second reason is the bar needs us to, pro bono program needs us to withdraw. So no, sir, we've sent letters to Ms. Bivens at 6035 Mauve in Port Arthur and included a notice of the hearing and a copy of our motion, and we've not heard back from her.
All right, I'll sign the withdrawal order. And let's see, what did I do with my docket? That was on Lopez. Was that
Yes,
the
sir.
Lopez?
Hey, Nate.
Yeah. This, okay.
Ask Tina
What is-
to request a copy of the order and send it to Melissa and to the client. Thank you.
Can we bring Mr. Henry on? And we'll go on to the,
Attaway.
Valdez. Oh, already signed one.
That was for DP.
Huh?
That was.
Hey, Mark.
It was scheduled.
Okay, so you cancel that.
Yeah.
Huh? Okay. that's local.
Thank you.
All right, can you hear me, Mr. Henry?
Not with audio here.
Can you hear me, Mr. Henry?
Can you hear?
All day.
I can hear him. He
I
apparently
can't.
can't.
Well, that's probably my audio. Join with audio. Why does it have me muted?
Can you hear me yet, Mr. Henry?
Yes, I can, Judge.
Okay.
Hey, Mark.
Hey, Larry, how are you?
I'm good, man. Good to hear you. See you.
All right, we're here in cause number 119599, the estate of Bertha Valdez Attaway deceased. We're here today on an application for an expedited order under Rule 736 and Chapter 355 of the Texas Estates Code on home equity reverse mortgage or home equity line of credit loan that was filed on March 8th by Mr. Henry. Apparently, it was a authenticated secured claim that was approved by the administrator back in September of 2020 as a preferred debt and lien. And so tell me where we are.
Yes, Your Honor. We were just asking for an order to foreclose the home equity deed of trust. This actually, the estate only owns a 1/2 community interest in the property. Mr. Dowden has obtained an appraisal of the property. The appraisal came back at $60,000. I'm not. My opinion is the house would not bring that on the open market, but at any rate, the state only owns a 1/2 community interest in the property. I have contacted the 3 heirs of Mr. Valdez. Mr. Attaway, that would be the owners of the other 1/2 community interest. But Mr. Attaway is deceased as well. And they came forward and they offered $35,000 which was less than it would take to satisfy the debt to the credit union, and less to take to satisfy the credit union as well as the expenses of the estate. I attempted to negotiate with them to pay a price that would at least pay for Mr. Dowden's fee as well as what's owed to the credit union. They would not come forward with sufficient offer to satisfy those obligations. And so at that point, we gave them notice of this hearing, and they have been served. They've been served with the application. They've received notice of this hearing and have defaulted. This morning, I have actually uploaded an affidavit of not with the attached non-military status for each of the 3 heirs of Mr. Attaway. It has not made it to the court's file yet, but I would testify that I have conducted an independent search of the military status records, online military status records, and neither of the 3 heirs that are parties to this suit and respondents here that have defaulted, that being Kevin Leon Attaway, John Eric Attaway, or Jason Edgar Attaway, were members of the military at any time that is pertinent to this case. There have been no payments made to the credit union by any party since the time the application was filed, and based upon the evidence before the court, we'd ask that the order for foreclosure be entered. Also, Your Honor, the order that we had originally submitted was a default order, and given Mr. Dowden's appearance, I don't believe that order is appropriate. So I've also uploaded another order for the court's consideration. It's just basically the same order, except it reflects Mr. Dowden's appearance rather than being a straight default.
Okay, Mr. Dowden?
No objection to Mr. Henry's petition, Your Honor. I feel like that property on a good day would sell for $25,000 on a good day. And the estate only has a 1/2 interest. I'm not opposed to his application.
Can you give me the exact amount, Mr.? I mean, you got one document that says that there was principal amount of $21,000. Okay, then you got interest, late fees, attorney's fees, showing total amount due is $33,857. That was okay. That was September 3rd of 2020. And then let me see what you're showing. You showed in your petition that was filed in March of 21. The amount to cure the default was $26,176. So has that changed since March?
Well, yeah, Your Honor, the petition says as of February, if I'm looking correctly, says of February 21, it's $26,000 plus attorney's fees and expenses. And I think that the difference there is that the approved claim included the attorney's fees in the case. The court may remember this was an unusual case in that we had filed one application and then we found a will, and we had to do some depositions in the case to prove up the will. And it's been a rather long.
That's why I'm wondering why the attorney fees were so high.
They are definitely high. Of course, there were 2 issues to deal with here. We had originally filed an estate proceeding for Mr. Attaway, and the 4 years passed on his. He had died intestate, so we ended up dismissing that application. Ms. Attaway, there was a granddaughter, and she actually appeared at the original hearing to appoint Mr. Dowden, that had told us that there was a lost will, and we had filed the application accordingly. And then when we got to the point of proving up the estate, she found the will, and we had to go through several different evolutions on this case to get where we are today. And I will grant you that the fees are unusually high, but it was rather complicated situation that
Very
drug
good.
out a
All
long
right,
time.
well, listen, I'll wait, I'll look for that amended order and we'll get it entered. And if either party needs anything, contact the court before this afternoon.
All right. Thank you, Your Honor.
Thank you, Judge.
Great week. It's lovely to terrace. Okay.